Hello everyone, this is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to This Week in FCPA, Episode 78 for the week ending December 1, 2017, the new policy edition. This week, Jay and I return, and we're joined by Matt Kelly for a wide-ranging discussion of some of the top compliance and ethics-related stories of the week. Obviously, the probably biggest one is the FCPA Enforcement Policy change that was announced by Deputy Attorney General Rod Rosenstein. Matt Kelly joins us for some of his thoughts on a deep dive into our initial impressions on that. We take a look at the SBM Offshore settlement of an outstanding FCPA enforcement action of a $238 million payment to the Department of Justice, coupled with SBM executives being prosecuted in the United Kingdom for their role in this bribery and corruption. We consider the ongoing FIFA trial in New York City and some of the revelations this week. We touch on Mike Volkov's three-part series on converging AML compliance into overall compliance regimes. Adam Turteltaub's visit with Rebecca Walker on assessing compliance programs on the SCCE podcast, Compliance Perspectives. We take a look at Roy Snell, who says you must have a passion for compliance, in an article on the SCCE blog. We touch upon the Supreme Court oral argument in the case of Digital Realty Trust under the issue of whistleblower protection under Dodd-Frank. It's a fascinating exploration of one of the most significant weeks of FCPA-related topics over the past 12 months. This Week in FCPA is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, the Compliance Evangelist, back again with my good friend and colleague Jay Rosen, Mr. Monitors, for This Week in FCPA, Episode 78, for the week ending December 1, 2017, the new policy the new policy edition. Jay, welcome.
Thanks, Tom. It's December 1st, so I wonder what kind of fun ethics, compliance, and FCPA things Santa has in his toy bag for us.
Well, Jay, if it's anything like the last week of November, it's going to be just stunning because we had an insane week of announcements, new policies, enforcement actions. We've got a lot to go over, so we can hop right into it. Probably the biggest news was the announcement of the change in the new FCPA Corporate Enforcement Policy by the Department of Justice. We're going to save that one towards the end because we're going to be joined by our colleague Matt Kelly, but we had a huge FCPA enforcement matter settled this week, Jay. It's the SBM Offshore matter. And this one had lots of twists and turns and different parts. It started back in 2014 when SBM settled with the Dutch Public Prosecutor's Office for $240 million. Then, a couple of years later, SBM agreed to pay Petrobras some $342 million in cash penalty and discounts on future work as a part of a leniency agreement with Brazilian prosecutors under the Clean Companies Act. Now we have them settling with the Department of Justice with a criminal penalty of $238 million, criminal fine of $500,000. $3.2 million in forfeiture, all paid on behalf of SBM USA. We also had the announcement we'll get into of two SBM executives pled guilty in the United States, and two more have been charged in the United Kingdom by the Serious Fraud Office. So really a number of different things going on here. Any part that really intrigued you more than one of the others, Jay?
Two things. One is just, the seemingly global scope of this and how all this went down at the same time, with SFO and with the DOJ. It also strikes me that this is a recidivist company, and, these are the situations that you're trying to avoid. That I believe the first time they settled with DOJ was in 2014. And now to have this come back so quickly, it's just really disappointing that the company wasn't able to make the changes the first time around.
Actually, I thought it was, I had a little bit different take, Jay. I thought that this settlement actually derived from the first settlement. And what I mean is that the first settlement was with the Dutch prosecutor's office. And certainly in 2014, many of us thought, wow, this is a really interesting that the DOJ would really cede all of the fines and penalties to another country. And I think this was the first case that did that. And then at one point, DOJ actually closed their file. And then about 60 days ago, I think SBM in an earnings call or in an 8K announced that they were reserving this $238 million for a fine and penalty with the Department of Justice. So something happened between those times. And then, of course, we had the individuals who either pled guilty or were indicted. Before we get to them, though, the SBM paid criminal penalties in excess of $475, but if you tack on the civil penalty paid to Petrobras, that's $819 million. That's, puts them in the top 5 of international anti-corruption settlements of all time. So huge enforcement action against SBM. They used money to pay bribes in Brazil, Angola, Equatorial Guinea, Kazakhstan, and Iraq. And then, of course, we had the individuals. So previously we had 2 individuals pled guilty in Houston, the former CEO of the business unit and the former territorial manager. The UK indictments were against a former vice president who was also Unaoil's general territories manager for Iraq, Kazakhstan, and Angola. So that's going to be interesting to see how Unaoil ties into it. And we had a senior sales manager from SBM. So really lots going on here, Jay. And I think the DOJ is sending a very strong signal to the compliance community that when the circumstances warrant, they'll drop the hammer. They won't be shy about charging big fines and penalties. They won't be shy about charging individuals. And to me, this is really a very strong message, particularly when you think about the kind of picture from 2014 going forward, if I have that right, that they really reopened the investigation at some point because of information that came to light in a manner, and then the individuals. So very interesting, I think very significant, and something that we're going to have to unpack in greater detail as it unfolds.
So would you attribute this directly to the current DOJ administration, that they've moved to this new point? Or do you think, again, that this was something that was left in the hopper at the end of the last administration and it's finally worked its way through?
I would lean towards, strongly lean towards the latter, but I would also say, Jay, that it really points to more continuity, that the professional prosecutors at the Department of Justice are continuing to enforce the law, and this is really just a continuation from what was started under the prior administration, in a long-winded way of saying that administrations may come and go, but the professional line prosecutors are still doing the job, developing the evidence, developing information, assessing cases, and then negotiating settlements with companies and with individuals now. So I really see this as complete continuity between administrations on enforcement of the FCPA by the Department of Justice.
Tom, it sounds like you might be making an approval of the whole deep state concept, that it could work.
Funny you should phrase it like that. Who is listening to this?
I don't know. Kislyak?
Perhaps. But
perhaps. So next,
this is just a hint.
Go ahead. Sorry.
Yeah, this is just a hint of what happened this week. You got some other things for us?
Yeah, I think you are a big football fan, both American football and global football, and we're starting to see some of the dominoes fall over in the FIFA case. And there's 3 articles that we're attaching to in the show notes, and they're all talking about basically a sports marketing person who was paying bribes out on behalf of different networks to try to guarantee rights to the different World Cups. So I think that's in a nutshell what it is. I know you found the articles. What was the part that interests you in this?
So as I think probably all of our listeners know, I'm from Texas, and we have a time-honored tradition and position here in Texas, and that's the bagman. And that's the guy who carries the cash. So I was very gratified to find that even in 2017, the bagman still exists, and he exists in the world of FIFA. The bagman took money to pay bribes, and so we had that. We had, anyone who has ever heard me speak, in addition to my podcasting repartee, understands that I say the three most important things about any best practices compliance program are document, document, document. So I was incredibly gratified to find that the individuals on trial actually have a bribe registry. So they have documented the bribes that were paid and or received. That's not the document I'm talking about, but nevertheless, a concept that is widely shared amongst various people. And then, of course, no trial would be complete without death threats and or neck scratching. I can't ever remember which it is. And we've had allegations that one of the defendants made a slicing motion across his throat to one of the witnesses. His lawyer said, well, you know, his collar was really just a little bit too tight. So we really don't usually get those in cases that are not kind of organized crime related. And maybe that's the final lesson out of this, Jay, that FIFA was just one big criminal organization that people were using. So just fascinating trial in New York City. Roy Snell, maybe take a little bit different direction, Jay, because Roy Snell had, I thought, a great article on the SCCE blog that talked about passion for compliance. And so that's something Roy talks about quite a bit. I'm the compliance evangelist. Obviously, I'm passionate about compliance. In the ancient world, in the Greek world, evangelist meant bringer of the good news, and that's what I think compliance is. But there was one part of his piece that I really thought was pretty significant, and I'd just like to read it, Jay. It's his last paragraph. He said, thought leaders will tell you the key to compliance is, and the answer is almost always different, and coincidentally what happens to be what the thought leader is passionate about. It's a trick question because there is no key to compliance programs. There are many keys. You have to audit, educate, analyze the rule of law, do risk analysis, develop policies, have an effective reporting system, build an ethical culture, and convince people to address known issues. You have to care about the big picture. You have to be passionate about the outcome of the compliance program rather than one element of the process. And the listing of those different elements really spoke to me about why the compliance profession is such a great profession. It is intellectually and emotionally challenging, but it calls upon you to have a wide variety of skills, certainly beyond just being a lawyer and having legal training. And Roy really laid it out in a way that I thought was most helpful, and for most compliance practitioners will help them articulate to management really what they bring to the table and what they have to do in their day-to-day jobs.
And I think that's one of the things that SCCE does so well in their conferences and their thought leadership and their magazines is that they're constantly stressing that this does not happen in a vacuum. And to be a successful compliance person, that you need to start building consensus within and across your organization, and you need to be able to provide those platforms where people can speak with each other, can not fear retribution, and that you can leverage information across an organization.
So we don't have, or rather we've linked to a podcast that I think everyone needs to listen to, which is Adam Turteltaub interviewed Rebecca Walker on assessing your compliance program on the SCCE podcast, Compliance Perspectives. And there's a Supreme Court case that touched on whistleblowers that I thought was significant. It involves whether or not employees who report internally receive protection under Dodd-Frank as opposed to Sarbanes-Oxley, or they have to go directly to the Securities and Exchange Commission. Oral arguments seem to indicate that companies were protected unless the employees went directly to the Securities and Exchange Commission, but we'll just have to see how that one shakes out. So, Jay, it looks like Matt Kelly has joined us, and we were saving this final sort of lengthy part of this episode to talk about the FCPA Corporate Enforcement Policy. And Matt, are you with us?
I am. Good morning, gentlemen. It's always a pleasure to make a guest appearance on this podcast.
Matt, do you have one mitten or two?
So the breaking news on my mitten blog post from earlier this week was 8 hours after I posted about my son's lost mitten. The lost mitten was then found in a corner of some other backpack that he had used. So I suppose it's a happy ending to that convoluted mitten story that I have on my blog, but I did have to first go buy another pair of mittens before I found the lost one.
Great.
Thanks for the update.
Yeah. So, Jay, you want to kind of set the table for us on why this was such a significant development this year, and then maybe we can get into our individual takes on it.
Yeah, so about 18 months ago, the government, or the DOJ specifically, came forward with, with the FCPA pilot program. And what it tried to do was incentivize companies to self-report. There was, if you self-reported, you would get a potential discount on the low end of the fine scale, somewhere between 25 and 50%. And then additionally, you would get either a deferred prosecution agreement, or you might actually get a declination. So that was in effect. And then when the new administration came in, many people were worried what was going to happen with the pilot program. And since we're now at the end of the year and it's conference season, and they had the big ACI conference in DC this week, Rod Rosenstein had an update on what they're going to do with the pilot program, and they're actually keeping it. They've made 3 key adjustments, and he stated that he doesn't want it to be known as a memo attributed to his name, like the Yates memo or any of the others, and it's going to be codified and directly part of the U.S. sentencing, not U.S. sentencing, but the but just part of kind of unpack and what we think about the changes that have been made.
So, Matt, what were your sort of initial thoughts?
Well, I'm not surprised at this. I think in various ways, Rod Rosenstein had telegraphed that something like this would happen. And when you think about what he and Attorney General Jeff Sessions have said, like the political logic of what they want to do, ostensibly what they want to do, points in this direction. They want to pursue individuals. They don't want to enforce or over-regulate companies. So therefore, we will sweeten the pot for you to cooperate with us, and then we will not charge you if you, the company, help us pursue the individuals. Like, that all makes sense. To go in the opposite direction of the Obama administration would actually have meant you'd be harder on companies and you wouldn't reward them for cooperation. That certainly was never going to exist in the Trump administration. We shouldn't be surprised that we are here. So I have 2 concerns about this, one kind of technical and specific, and one a broader political one. What interested me was that in his speech at the ACI conference, Rod Rosenstein said, even if the company chooses not to disclose, and then we find out about it anyways, and then you do cooperate, and then you do remediate, so you meet only the second 2 of the 3 prongs, even if you only do the 2, you'll still get some credit. Whoa. That is a big distinction. And my question is, how much credit do you get if you don't disclose. Because if you still get almost all of it, then suddenly there's a big incentive for the company just to keep your mouth shut until the Justice Department comes after you. And they don't have the budget or the political appetite to come after you. Now, if you get only a tiny bit of credit for the cooperation and the remediation, but you still really get stuck because you didn't self-disclose, then we're in good shape. But I would like to see more about how's that going to work in practice. Which leads me to my second bigger concern. I think that this program, this idea, this is a very versatile tool, good, fine, it's very reasonable if the enforcement wing of the Justice Department handles this seriously. And we have been seeing all summer long into the fall, seeing it right now, today, we are seeing the Trump administration's inner circle slowly push out those people who do take their jobs seriously and who might then become a voice of independence against what President Trump wants. And then they get broomed. And we've seen this, for example, at the State Department, Rex Tillerson on his way out. He will be replaced by probably Mike Pompeo from the CIA, who is just going to be a yes man who gives Trump what he wants. And Pompeo will be replaced by Senator Tom Cotton from Arkansas at the CIA, who is just going to be a yes man and give Donald Trump what he wants. There isn't going to be any voice in the diplomatic side to be a counterweight to Donald Trump and ask, Mr. President, are you sure you want to do this? We've seen the same dynamic in the Treasury Department, where they were saying the tax reform plan would pay for itself. And actually, it isn't going to pay for itself. And the policy analysts at Treasury, the apolitical career people who just do analysis, who said that this won't work, they've been pushed out. We've seen it actually within the Justice Department already, where Dana Boente, who was the head of the National Security Division, who must have approved applying for a FISA warrant by Bob Mueller, who then turned around and indicted Paul Manafort. Within days, Dana Boente announced he was leaving. You see all of this. If that dynamic infects the criminal division, infects what Rod Rosenstein is trying to do, if Rod Rosenstein gets pushed out, then this policy idea we've been talking about under the wrong hands could make FCPA enforcement just a big dead letter. And that's my question. I don't think Rod Rosenstein is going to get pushed out because he has enough political cover these days that this would look bad or would look like Donald Trump's trying to shut down the Russia corruption probe. But you have to wonder what Donald Trump might do. And how will this policy work with the new head of the criminal division, who has his own Russia allegations swirling around him? How will this work with the deputy AG? We don't know. But it could work very poorly. It could make a lot of what we talk about just a paper compliance program if we have a paper enforcement. And that's going to be my question. And that's where Rod Rosenstein and the U.S. attorneys have to show that they're serious about this. Because it's not wrong to say that a lot of the administration isn't serious about the rule of law. That's where my head is on this. But policy itself could be good, could be sensible. That's where I am.
So, Jay, did you have some initial thoughts?
Yeah, the more and more I hear Rosenstein speak and read his stuff, I like the fact that he's kind of a no-nonsense guy, that there's not a lot of flowery language, there's not a lot of complicated stuff, it's just the facts. And I think from the perspective of keeping this program and having continuity to the last administration and having a tool that career enforcement people can use is a good thing. I do actually agree. I do share Matt's concern that it's always going to be left up to how this tool is used. Will it be used to rubber stamp situations, and will it become a checkbox exercise? Hopefully not. But I think as it is right now, when we talked earlier in the podcast with the career prosecutors, if they are taking this seriously, I think it's a good mood. And I think it builds upon, in the past, people have questioned, well, where are the data points? And I think They've successfully shown that the pilot program over the last 18 months has brought more cases to light. And as we just spoke about with SBM, we're starting to see more individual prosecutions. So both things seem to be trending in the proper direction.
Yeah, and I guess from my perspective, I saw things a little bit differently because I was focusing on the compliance practitioner, the compliance professional, the compliance program aspects of this. And when I coupled it with the speech where Rosenstein announced it at the ACI conference this year, the National FCPA conference, I really saw a lot of things that heartened me. In the speech, he really talked about, he moved beyond talking about anti-corruption or anti-corruption enforcement in the context of terrorism or crime to really speak about it as an economic issue. And we saw this in Saudi Arabia where even the Crown Prince MSB talked about the cost to the Saudi economy of 10% lost for bribery and corruption. But Rosenstein specifically called out corruption as causing or leading to increased prices, substandard products and services, and reduced investment. And I really appreciate focusing on the economic aspects of corruption because I think that really gives it a non-political driver as well. And I think that's part of where the discussion not only has been going, but should be going. But the other part was it really heartened me about the compliance program function in the new policy. It is not simply the people who wanted to have a compliance defense, those people who wanted to have a paper program, you have a program and get out of jail card. This is a much more comprehensive approach. You do have to have self-disclosure. You do have to cooperate fully. You do have to remediate completely. And you do have to disgorge your profits if you want to take advantage of the pilot program. But within the context of the compliance program itself, it incorporates the 10 hallmarks of an effective compliance program through the 2012 FCPA guidance, and then added some additional points that were included in both the 2016 pilot program, particularly around the resources made available to the compliance function, and then the compliance practitioner's ability to be promoted within the corporate organization, in addition to the risk assessment that we saw, or excuse me, the root cause analysis that we saw so well articulated in the 2017 Department of Justice Evaluation of Corporate Compliance Programs document, which was released in February of this year. So I really see an evolution of the Department of Justice around compliance programs. I see an evolution of the Department of Justice in putting compliance practitioners really in the center of this entire debate. And I really saw it to strengthen the entire compliance regime literally across the globe, because Rosenstein in his speech talked about international enforcement and international compliance with anti-corruption and anti-bribery laws. So from the practical side, I think there's more. From the sort of political side, the concerns Matt has raised are certainly great questions to ask. And I think they're questions that we will be paying attention to going forward. But I'm certainly encouraged by this. I don't think it was any coincidence that on the same day this policy was announced, this policy changed, the SBM Offshore case was settled. And to me, the DOJ is sending a very clear message that when circumstances warrant it, we will certainly, like I said earlier, bring the hammer down on both corporations and individuals. So I see a lot to unpack. I see a lot for us to consider, and I see a lot for us to watch going forward.
Tom, could I raise one other observation?
Sure.
So one thing that did strike me was last week I had a post from a federal judge here in Boston who wrote a really blistering opinion about corporate plea bargains. It was not in an FCPA context. It was a drug company that was facing some improper marketing charges, but it had pled out with what looked like a very easy plea from the Justice Department. And the judge was irate that he had a approve it or reject it choice, and he had no ability to exercise any independent questions about why this plea is what it is. And he was complaining that really these plea bargains move away from letting the judicial branch have some oversight into corporate misconduct. He's not wrong to say that, but what Rod Rosenstein is proposing here does move exactly opposite from what that judge and other judges would like to see. This is going to mean less judicial review because there may not even be any case. There's going to be a declination. It's not even going to get to a trial. I can only imagine that federal judge, William Young, would be rather irritated to see this kind of policy taking root. It looks great on paper for corporations and for compliance officers and for prosecutors, but those traditionalists who say we're getting more cases and establishing precedent, you're out of luck.
That's an interesting observation that is well put as well. So, Jay, any kind of thoughts based upon what matter I've said?
A couple more things as your idea sunk in. I think in terms of the context of operating a business on a global, on a global stage, one of the things that this iteration of the program brings is a lot more certainty. So if you're a business owner, you want to know certainty, you want to know what's going to happen if I do this, and there's still going to be that internal calculus that every firm is going to do. But if you know you're going to get a declination out of it, this allows you to move forward. From the DOJ's perspective, I think starting back in 2012 with what Chuck DeRoss did and moving forward in these 5 years, we've just upped the ante in terms of there's a lot more transparency in terms of what the DOJ expects in a compliance program. And there's a lot more transparency about what they're looking at and how they're going to prosecute things. So we've got certainty, we've got transparency. My only concern is whether all this is going to be real or lip service. And we keep coming back to the repetition of AG Sessions thing that, we want to be a society that looks to the rule of law, and that it seems to be at some point minimizing all this FCPA and anti-corruption stuff because they're saying, well, we want to spend less time working on these FCPA cases so we can do more of the things that are threatening our society and looking at more criminal elements and looking at gangs and looking at immigration. So I guess my glass half full ending on my thoughts is that I also do kind of share some of Matt's concern that if they're going to give these FCPA short shrift just to move on to the bigger cases, if that's going to happen, it's a negative. But if Rod Rosenstein is just mimicking the party line, the Sessions line, just to say how this fits into the strategy, and we're able to keep this FCPA enforcement moving forward, then I think it's a good thing.
So unfortunately, we're near the end of our time, Jay. So if I could just touch on a couple of things. I start a new 1-month series on my 1-year series of podcasts on a more effective compliance program. This month, I'm going to focus on written standards in a best practices compliance program. Also, yesterday, the Everything Compliance Gang released yet another podcast. In episode 21, we discussed the AT&T merger and some antitrust issues, the Paradise Papers, issues around corporate monitors, and considered some DOJ comments on FCPA enforcement. Finally, the Everything Compliance Gang put together an ebook of their reflections from the SCCE 2017 Compliance and Ethics Institute. It's available for download free on JD Supra and on the affiliated monitor site. We will link to those in the show notes. So, Jay, with that, you want to take us home?
I'll give it a shot. On behalf of Tom Fox, the compliance evangelist, Matt Kelly, Mr. Radical Compliance, and myself, Jay Rose, and Mr. Monitor, we'd like to thank you for spending your time with us this week or weekend, listening to This Week in FCPA Episode 78 for the week ending December 1st, the new policy edition. Thanks so much and take care.
This is Tom Fox again. I'd like to thank you for listening to Episode 78 of This Week in FCPA. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast, as it would help in our rankings and also help get the word out about the only compliance and compliance-related weekly podcast which summarizes the events of the week. Also, if you have any questions, you can email me at tfox@tfoxlaw.com. You can reach Jay at jrosen@affiliatedmonitors.com. Thanks for listening to this episode of This Week in FCPA, and I hope you'll join us again next week when we wrap up the events and stories from the week of December 4, 2017. This Week in FCPA is a part of the Compliance Podcast Network.